All right, welcome back to our examination of your relationship with lawyers in the American legal system. This is part 2 of 2. In this installment in the series, we are going to look at hiring and working with an attorney. Recall that in the previous part of this series, we looked at determining when you would need an attorney and how you would go about finding one in the event that you did decide that you required an attorney's services. Begin with hiring a lawyer. You need to find a specialist. You need to find a lawyer who has the knowledge and the background and a track record of success in the legal area that pertains to your case. So find that lawyer with expertise in the subject of your case. This means you're not necessarily going to pick the lawyer you know or that someone recommended to you. They might be a very good attorney, they might be a close personal friend. If they lack the expertise you need, then they are still not a good choice to be your attorney for that particular case. Second, and this is the part that can be rather uncomfortable, talk money. And a lot of people don't like to talk money. They don't like to negotiate, they don't like to haggle. But it is a necessary part of life. Talk money. You would not hire many other services without knowing upfront what it's going to cost. And you certainly don't want to do that with a lawyer. Their services are some of the most expensive that you might ever purchase in your life. Right? So talk money. Right? That means you need to know what is the fee. How are they going to charge you? What are they going to charge you? Is it going to be an hourly fee, right, where every conversation that you have with your attorney, every minute they spend working on it is going to be billed? If so, right, you're going to want to be very efficient in your dealings with your attorney. Right? You're not going to bring up outside subjects when you talk with them. You're going to keep it very much on point to keep those costs down. On the other hand, you might be looking at a flat fee where the lawyer is going to look at your case and present you with a cost up front of what you're going to have to pay. The fee might also be a contingency fee. Right? This means the lawyer is only paid if you win in court, right? Or if you settle favorably your case. So again, it means you are only paying the attorney if the attorney wins your case. Right? And typically this applies in things like personal injury cases. Right? You'll see these on television advertisements where an attorney will tell you that there's a no fee guarantee perhaps, and that you don't pay anything unless the attorney wins. If they do win, their fee will usually be 30% or more. Right? You can expect to pay perhaps up to 40%, in some cases even more than that. The other question is, when must you pay? You want to know, am I going to be billed monthly? Am I going to pay at the end of the case? Right? How is this going to work? You should also get a contract. You want to detail those fees, those issues we talked about. Is it going to be hourly, flat fee, contingency fee? You need to also understand the billing procedures. Is there going to be maybe a down payment that you have to pay, which is called a retainer? We also need to look at the client-lawyer relationship. It goes beyond hiring the attorney, of course. That's just the beginning of your relationship with that attorney. And we need to understand that client-lawyer relationship is built on trust. A big component of that trust is what's known as attorney-client privilege. And what that means is what you say with your lawyer is privileged. Well, gee, thanks, Dr. Brown. Privilege is in there, and you have just used the word privilege in the definition of privilege. Well, so let's get past that sin of defining terms. It means what you say with your lawyer is confidential. The lawyer cannot disclose that to the court or anyone else. Right? It is a true secret between you and your attorney up until the point that you choose to release that information. If you free your attorney from attorney-client privilege, then they can disclose information about their discussions with you. Otherwise, they are bound to secrecy. The other thing to understand is that final decisions in your dealing with your attorney are your own. Lawyers have specific jobs in this relationship. They are there to advise you, and they are there to represent you. But ultimately, the decisions about what advice you accept or reject, or in the specifics of how you want to be represented, those are up to you. All right, let's look now at lawyer responsibilities. Right. Lawyers' responsibilities are determined by a code of professional conduct or professional responsibility. And it's based on a system of canons, specifically 9. Now, these canons pertain to ethics, issues of right and wrong, and also rules set up by the legal community. The first of these is that all attorneys are supposed to work to ensure the continued integrity and competence of the legal profession. So to make sure that it remains respected, that it remains true to its purpose, and that it retains people with the knowledge, the competence, the skill to continue the work of attorneys. Lawyers are also supposed to make sure that they are doing their part to make legal counsel available. Right? That doesn't mean free, although in some cases there are cases that lawyers will take for free. Those are known as pro bono cases. There are legal charities and such, but the idea is to have enough lawyers with enough skills so that legal counsel is available. It's also meant to prevent unauthorized legal practice, so making sure someone is not advertising themselves as a lawyer when in fact they do not have the credentials to serve as a legal professional. Also, to preserve client confidentiality. Goes back to that attorney-client privilege. Attorneys are also supposed to make sure that they are exercising independent judgment. So you have the final say in your relationship with your attorney, but they are supposed to use their own best judgment in performing their part in the relationship. They're also supposed to represent their clients completely and all of their interests related to the case, and also perhaps in terms of the public relationship of their client during the court process. And attorneys are also supposed to be very zealous in representing their clients. They can't break the law to do this, but everything that is within legal limits they are supposed to do in the representation of their client. Nearing the end here, lawyers are also supposed to improve the legal system. So where they find flaws, they're supposed to work to change those flaws. It might be in cases of civil asset forfeiture, might be in cases of improper conviction, all kinds of criminal justice issues. Lawyers are supposed to correct problems and in general improve the legal system in the course of their careers. And finally, lawyers are supposed to make sure that they do not ever create the appearance of professional impropriety. And impropriety means something that is improper, unseemly, shady, dodgy. Choose your adjective, formal or slang. They're supposed to make sure that the legal profession is not contaminated by impropriety. All right. That may seem like a tall order, and it is. And there are cases when lawyers fail to meet their obligations. And when that happens, there are punishments for failure. Some of those are in terms of professional punishments, professional sanctions. These are going to be handled by bar associations, maybe the American Bar Association, maybe state bar associations. And remember, those are the organizations that license attorneys, right, which gives them a lot of power. They can, at the lower end of things, reprimand an attorney, which is kind of like a slap on the wrist or a scolding. The lawyer is told that they have done something wrong. What they've done is detailed correctly, and maybe the course for further action, if such failures continue, will be laid out in that reprimand. Right. The next step would be a suspension. Right? A bar might suspend an attorney's license to practice, and during that time, the lawyer cannot make money using their legal expertise. And at the most severe end, an attorney can be disbarred, which means they are stripped of their license permanently and they can no longer practice law. And that is, of course, a very powerful legal or professional sanction for attorneys who fail to meet their obligations. There can also be legal punishments for lawyers who fail to meet their legal obligations. Just as with medical cases, there can be legal malpractice. If an attorney has not done their job correctly and they have cost you money or cost you your liberty in terms of a prison sentence, you can sue them for malpractice. It's very much like a medical case, as we see in this advertisement here. Sue your lawyer? Sure you can. These would be a civil suit for damages, much like a breach of contract or, again, a medical malpractice case. Now, in some of these cases, what you might find is that there's going to be an arbitration clause, and that might be something that was drawn up in your contract with your attorney, in which case the Bar Association will hire arbitrators or get a panel of people together to look at your dispute with your attorney, and they may reach a decision. This is especially common in cases of fee disagreements between attorneys and their clients. All right, and that concludes the second part in our look at lawyers and you. All right, take care, be safe, and I will see you in class.